Where does a federal case actually begin in the United States? Which court is the proper place to file a lawsuit? And how can you tell whether a court is a trial court or an appellate court? If you are a lawyer, an immigrant, or preparing for a legal career in the US, you must understand the structure. The truth is that most people have no idea how the US court system actually works. What is the difference between a federal court and a state court? Why does America have not one court but an entire system of hundreds of courts? And most importantly, how do you identify each court, understand its jurisdiction, and know where to file an appeal? My name is Asel. I'm a lawyer and a former judge. And today I will explain the U.S. judiciary, its structure and constitutional foundations based on the U.S. Constitution, clearly, simply, and structured way. If you watch this video until the end, you will finally see the system the way American lawyers see it. To understand the system, judicial system, we must begin with the Constitution. The entire judicial branch is described in just one article. It is Article 3 of the U.S. Constitution, which contains three sections. Section 1 established that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. This means the judicial power belongs to one Supreme Court and to lower federal courts which Congress may create whenever necessary. It also guarantees judicial independence. Article 3, judges hold office during good behavior, for example, and their compensation cannot be reduced while they serve. The U.S. Constitution mandates the establishment of a single Supreme Court, but it deliberately does not prescribe the number of justices who must serve on that court. The size of the Supreme Court is therefore determined by Congress. At present, as today, the court consists of 9 justices and 1 Chief Justice and 8 associate justices. Article 3, Section 2 defines the scope of the federal judicial power. It provides that federal courts have jurisdiction over cases arising under the U.S. Constitution, federal statutes, and treaties of the United States, as well as cases involving ambassador, consuls, admiralty, and maritime law, controversies to which the United States is a party, controversies between two or more states, controversies between a state and citizen of another state, controversies between citizens of different states, and controversies between U.S. citizens and foreign state or foreign nationals. Article 3 also provides that all federal crimes, except impeachment, must be tried by a jury, and trial must be held in the state where the crime was committed. Section 3 defines treason against the United States. It is striking that treason is defined in the judicial article, not in the criminal and not political section, Why do you think that is? Please share your thought in the comments. I will wait, okay? I believe that the framers deliberately entrusted the most sensitive accusation to the independent judiciary, not to politicians. As I said in the previous video last time, the framers built an extraordinary balance between government power and individual rights. I think it is if the Constitution says yes, the government has power, of course, but the final words belong to the courts. And as a former judge, I feel this especially deeply. The judiciary is not just the third branch. It is a guardian of freedom, law, and justice. The U.S. judiciary is a system of courts based on several key sources of law. The first of all, the U.S. Constitution, of course. It also includes federal statutes and state constitution and other state laws. The court were not created by one single law or at one specific moment. They developed gradually over many years through numerous laws passed by Congress. Given the format of the YouTube channel, I want to emphasize that today the main federal court governing the structure and operation of the federal judiciary is Title 28 of the United States Code, Judiciary and Judicial Procedure. At its core, the judicial system of the United States has a clear and logical structure. It consists of three levels. Please take a look at the diagram. At the first, you can see the trial courts, where cases are heard and decided on the merits. The second, appellate, and Supreme Court, which highest judicial authority in the country. It is essential to note that the United States operates two parallel court systems, federal court and state court. That system is function independently of one another, each within its own jurisdiction. Today, in this video, we will focus exclusively on the federal court system because the state court system will be examined in the detail in the next video, okay? Now, we will talk about courts which Congress created. Congress has created all federal courts except the Supreme Court of the United States, and which established directly by the Constitution. This court include U.S. Court of District Court, U.S. Court of Appeal, Court of International Trade, Bankruptcy Court, Tax Court, Court of Federal Claim, Court Martial. For analytical purposes, the courts may be broadly divided into two categories. Court created under Article 3 of the U.S. Constitution, legislative court created under Article 1. What is the difference between them? Court created under Article 3 enjoys strong constitutional guarantees. Judge of these courts are appointed for life during good behavior, which ensures their judicial independence, and that their salaries may not be diminished while they hold office. Legislative courts, by contrast, do not enjoy these constitutional protections. Their judges are appointed for fixed term through different appointment mechanism and without lifetime tenure or salary protection. For this reason, legislative courts are often referred to as a specialized court. It is important to note that court-martial are not courts of general jurisdiction and are not part of judicial branch established under Article 3 of the U.S. Constitution. They operate separately and in parallel to the federal judicial system. Court-martial function within the military justice system and are subordinate to the executive branch, as they are governed by the Uniform Code of Military Justice. Please take a look at the diagram. This is how the federal court system of the United States is structured. At the top of the system is the United States Supreme Court. Below the Supreme Court are the United States Court of Appeal, organized into 12 federal circuits. At the base of the system are the United States District Court, consisting of 94 judicial districts. As I mentioned earlier, the U.S. Supreme Court is the highest court in the federal system, and it hears cases selectively, primarily for the writ of certiorari. Now, let us turn to the appellate level of the federal judiciary. In the United States Courts of Appeal, Court of Appeal, do not conduct a new trial. They do not reconsider cases from the beginning, do not hear cases on the merit, do not admit new evidence, do not examine witnesses, and do not make independent finding of fact. The role of U.S. appellate courts is narrow and clearly defined. Its task is to review whether the trial court correctly applied substantive law and properly complied with the procedural rules. In other words, appellate courts determine whether legal or procedural error occurred at the trial level. This approach differs fundamentally from the appellate model used in the many countries, for example, of Central Asia, where I lived before United States, where appellate courts may rehear cases on the merits, admit new evidence, hear additional witnesses, and issue a new decision which replaces the judgment of the lower courts. U.S. appellate courts do not possess such authority. The U.S. Courts of Appeal are courts of general appellate jurisdiction created under Article 3 of the U.S. Constitution. They consist of 12 federal circuits, 11 numbered circuits, which you can see on the map of the United States, and the District of Columbia circuits, which is counted as the 12 circuits and plays particularly important role to its jurisdiction over cases involving federal agencies and the executive branch. This court hears appeals from the U.S. District Court and certain federal administrative agencies. In addition, the U.S. Court of Appeal for the Federal Circuit is a specialized Article 3 appellate court with a nationwide, non-territorial jurisdiction. It hears appeal from the U.S. Court of Federal Claim, the U.S. Court of International Trade, and other specialized subject matter cases, including patent law. As a practical matter, appellate jurisdiction is usually geographic. For example, case from California go to the Ninth Circuit, while cases from New York, for example, go to the Second Circuit, whereas jurisdiction of the federal circuits depends on the subject matter, not location. You may also see the U.S. Court of Appeal for the Armed Forces. This court operates parallel to the federal courts because it's not part of the Article 3 judiciary and function within the military justice system under the executive branch. It is included here because its decision may be reviewed by the U.S. Supreme Court. So, where does the federal cases actually begin? In the trial-level courts, which include U.S. District Court, specialized federal trial courts. District courts are the general trial courts for federal cases. Why 94 when the U.S. has 50 states? It is important questions because Congress created as many districts as necessary for efficient case management. Large states have multiple districts, for example, California 4, New York 4, Florida 3. Small states have only one. District courts also exist in Washington, D.C., Puerto Rico, Guam, Northern Mariana Island, and Virgin Islands. Total will be 94 federal judicial districts. What cases do district courts hear? There are the primary federal trial courts, and here federal criminal cases, civil cases, and diversity cases exceed 75,000. It is diversity jurisdiction. Why aren't specialized courts shown on this map? Because the map shows geographical district and circuit. Specialized courts have non-geographical and nationwide jurisdiction. For example, Court of Federal Claims nationwide, Court of International Trade located in New York City but national jurisdiction. Tax court sits nationwide. Bankruptcy courts function within the 94 districts. Court martial operate by personal jurisdiction. Who can file in specialized court? To tax court, taxpayer disputes IRS decision before paying tax. Court of Federal Claim, monetary claim against the U.S. government. Court of International Trade, importer, exporter, and trade disputes. Bankruptcy courts, any debtor filing under Chapter 7, 11, or 13. Finally, district courts from the foundation of the federal judicial system. There are 94 districts determined by Congress, not by the number of states. They handle almost all federal trial-level cases. Specialized courts are not shown on the maps because they have national or personal jurisdiction, not territorial jurisdiction. They accept only specific categories of cases of petitioners. Thank you for your attention. Subscribe to the Asel Lawyer channel In the next video, I will talk about state courts, and that is an entirely different legal labyrinth. Oh my god. I will explain the New York court system, where surprisingly the trial court is called the Supreme Court. How? Oh my god, trust me, it will be a real mind-blowing moment. Thank you. Bye bye.